that the defendant is present, but her counsel is not present. Assistant State Attorneys are present. We are here on a scheduled matter scheduled by the defense on their motion to reconsider Ms. Anthony's motion to declare Florida Statute 921.151 unconstitutional under Ring versus State. We'll see whether they show up or not. Was Ms. Fennell to appear by phone, Mr. Ashton?
That was my understanding, yes.
By phone. Do we know what number she was supposed to dial into?
Yes, I gave the number to them, yes.
I have the number, she's on this line.
Good morning, this is Steve Gislandi for the Ninth Judicial. Can you hear me?
Yes, I can. This is Ann Fennell on the line. Thank you.
Okay, Ms. Fennell, Ms. Anthony is present. None of your other co-counsel are present. You scheduled this matter at 8:30. The time is now 8:32. Mr. Ashton is present. You may proceed, ma'am.
Thank you, Your Honor. I have filed a motion to reconsider Ms. Anthony's motion to declare the Florida Statute 921-141 unconstitutional under Ring versus Arizona. I have attached to my motion a memorandum of law in support of that motion to reconsider, as well as appendix to those two issues, the case of Paul H. Evans versus Walter A. McNeil out of the United States District Court for the Southern District of Florida, Miami Division, which was rendered by federal District Court Judge Jose Martinez on June 20th, 2011, in which he granted habeas relief on this very issue, declaring Florida's death penalty statute unconstitutional. I will rest on the motion, the memorandum, and the case law provided, unless the court has specific questions for me that I will be willing to answer.
One question.
Yes,
One of
sir.
the remedies that you asked for is the remedy of a mistrial. Is that correct?
That is correct.
Have you consulted with your client about that, and does she consent in the request for a mistrial?
Your Honor, I have not directly consulted with her. I believe that issue has been consulted with her by Mr. Baez and or Mr. Cheney, and I believe that she does concur with that issue, although if one of those two gentlemen is present, or Ms. Sims, perhaps they can do that at this time just to be on the safe side.
Unfortunately, they are not here. Ms. Anthony is at counsel table alone. You are appearing by phone, but I will ask them whenever they choose to arrive.
That would be fine, Your Honor. I feel confident that Ms. Anthony would agree with this issue as it involves the constitutionality of the death.
Ms. Anthony, do you want to answer
statute.
that question now? Do you want to wait till Mr. Baez or Mr. Mason or Ms. Sims arrive?
I can answer that now.
Okay.
I agree with Ms. Fennell.
Thank you, ma'am.
You're welcome.
Thank you.
Mr. Ashton?
Yes, sir. At the outset, I would point out to the court that, according to the Attorney General of the state of Florida, this opinion is not final as of yet. A motion to alter judgment is pending before the District Court of the Southern District of Florida. So at this point, this is not a final order. Further, it is apparent from the order, particularly starting at page 92, that this is an as-applied finding by the court. The court goes into great length, concluding, and I will cite the particular language. This is page 92 of the opinion. Any one singular aggravating factor may not have been found beyond a reasonable doubt by a majority of the jury. The court's interpretation of Ring is such that at a very minimum, the defendant is entitled to a jury's majority fact finding on the existence of an aggravating circumstance, not simply a majority of jurors finding the existence of an unspecified combination of aggravating factors upon which the judge may or may not base a death sentence. Because the jury may not have reached a majority finding as to any one aggravating factor, the Florida sentencing statute leaves open the very real possibility that in substance the judge will make the factual findings necessary for the imposition of the death penalty as opposed to the jury as required by Ring. Habeas relief is granted. This is an as-applied analysis of the particular case of Mr. Evans. It does not invalidate Florida's sentencing scheme entirely. It simply, if in fact this were final and were affirmed on appeal, would simply indicate that as applied to Mr. Evans and the unique facts of his case and the procedural history of his case, it was unconstitutional. It does not prohibit the state of Florida from proceeding to pursue the death penalty in any other case other than perhaps Mr. Evans' case.
Did Mr. Evans' case involve felony murder?
Your Honor, I don't believe it. I'm not sure. I know that there was a finding by the jury of pecuniary gain, and I don't recall if this was a felony murder, a case where the jury found a felony beyond a reasonable doubt. I just don't recall. I apologize.
Ms. Fennell, would your argument still be plausible if the jury came back with a verdict and found Ms. Anthony guilty of the crime of aggravated child abuse, which would require unanimous vote?
I understand the court's argument, Your Honor. Certainly the cases that have been upheld in a Ring analysis by the by the Florida Supreme Court to date have dealt with that very situation where either a jury has made a finding of a felony that would qualify for felony murder analysis, or a situation where there is a prior violent felony, which, of course, under the Apprendi analysis does not require a finding by a jury because it's a sentencing consideration. However, I think we should be concerned with the district court's finding, specifically at page 91, the end of that particular page where where the court is saying that in relating to footnote 33, which, if I can take a minute to read into the record, says the Florida Supreme Court reviewed this issue on a very limited certified question from the 2nd District Court of Appeal. They're talking about the Steele case, of an order from the trial court requiring a majority of jurors to agree on the existence of a particular statutory aggravating factor. The court found that unless and until a majority of this court concludes that Ring applies in Florida and that it requires a jury's majority or unanimous conclusion that a particular aggravator applies, or until the legislature amends the statute, see our discussion at section C below, the court's order imposes a substantive burden upon the state not found in the statute and not constitutionally required, citing the State versus Steele. The court, the federal district court goes on to section C is entitled "The Need for Legislative Action." In section C, the court begins with the fact that Florida is now the only state in the country that allows a jury to decide that aggravators exist and to recommend a sentence of death by a mere majority vote. Here the court finds that Ring does apply in Florida and that the Florida sentencing statute is unconstitutional. So in that regard, I disagree with Mr. Ashton's analysis that in Evans, the district court is merely finding the Florida statute unconstitutional in an as-applied manner.
On the Evans case, this was a contract murder. It was not a felony murder.
Okay.
And he was not he was only charged with one count of first-degree murder.
Okay, anything else, Ms. Fennell?
No, sir.
Anything else, Mr. Ashton?
No, sir.
The court has reviewed the following cases. Bodison versus Moore, which is found at 833 7 Second 693. A 2002 decision of the Florida Supreme Court. Mr. Bodison, in that case, raised a ring issue. As you can remember from the history of Bodison, there was a stay of execution issued by the United States Supreme Court during the pendency of Ring versus Arizona. That stay was lifted shortly after the decision in Ring versus Arizona, and the issue was raised. For whatever reason, the United States Supreme Court did not address the Ring issue. Subsequent to that, Mr. Bodison was executed on December 19, 2002. The court has reviewed Amos Lee King versus Michael Moore, found at 831 7 Second 143. Again, a 2002 decision of the Florida Supreme Court. In that particular case, they again bring up the issue of Ring versus Arizona. Mr. King's death warrant was pending at the time of Ring versus Arizona. The U.S. Supreme Court declined to rule or declare the Florida scheme unconstitutional at that time. Mr. King was subsequently executed on February 26, 2003. The court has reviewed Blackwelder versus State, a 2003 decision of the Florida Supreme Court, found at 851 7 Second 650. In that particular case, again, the issue was brought up dealing with Ring versus Arizona in the Florida sentencing scheme. Mr. Blackwelder was denied relief, and he was executed on May 26, 2004. The court has also reviewed the case of Robertson versus State, which is found at 865 7 Second 1259, a 2004 decision of the Florida Supreme Court. Again, the issue of Ring versus Arizona and the Florida death penalty sentencing scheme was again brought up in that particular case, along with a myriad of other issues. Particularly, the Ring issue was brought up in a habeas corpus petition. Relief was denied, and Mr. Robertson was executed on February the 4th, 2004. The court has also reviewed the case of Arthur Dennis Rutherford versus State. That case is found at 940 7 Second 1112, a 2006 decision of the Florida Supreme Court. Again, we have another Ring versus Arizona issue. Mr. Rutherford attacked the Florida sentencing scheme again. Relief was denied. He was executed on October 18th, 2006. The court has reviewed the case of Hilliard versus State, which is found at 883 7 Second 753, a 2004 decision of the Florida Supreme Court. In that case, along with a number of other issues, the issue also was brought up pursuant to Ring versus Arizona, dealing with the Florida sentencing scheme. Relief was denied, and Mr. Hilliard was executed on September 23rd, 2008. Since The court, though, at this time will reserve ruling on the motion for mistrial and not rule until a subsequent date on the defense request for mistrial and also the defense's motion to reconsider declaring Section 921.141 unconstitutional pursuant to Ring versus Arizona. The court will reserve ruling on this particular motion.
Thank you, Your Honor, and thank you very much for allowing me to present this by phone.
Okay, if there's any subsequent rulings in this particular case out of the Southern District of Florida, please let me know.
I will, Your Honor.
But I will rule on the request prior to the receipt of the verdict if we get that far in this case. All right. Thank you very
again.
much. Okay, we will be in recess. Are there any other matters we need to take up prior to bringing the jury back in at 9 a.m.?
I don't know any right now. It's taking about a half hour to get in here.
Which door did you come in, Mr. Mason? Okay. All right, we'll be in recess to 9 o'clock.